Speaker.
I call Ron Mark.
Speaker, I rise on behalf of New Zealand First to indicate that we will be supporting the passage of this bill. I think the points have been pretty well traversed this way at this point in time. As always the case, when you get one of the late speaking slots, most of the members have covered off with the points, but I will for the record state that New Zealand First does accept the logic behind the bill, and I'm going to digress just a tad, because I do accept that there are some people who think that lowering the compliance costs for pool owners might well be aimed at one particular sector of the community, that is the people who are fortunate enough to have very flash homes and big flash swimming pools. I was going to put on the record in the Hansard the admiration I have for a gentleman who lives in Carterton, who out of the kindness of his heart gave a family who are not what you would call a rich, wealthy family a swimming pool for Christmas, because they'd done things over time to assist him and make his life better, and one of the things he thought he could do to help them, and particularly to provide some entertainment and a facility that their children had never been able to enjoy and probably could never afford to pay for themselves, a swimming pool. Of course, with that came the obligations of meeting the requirements of the Swimming Pool Fencing Act. And so the compliance issues around pool fencing in that case are not compliance issues reserved just for the wealthy. These are compliance issues that affected an ordinary, everyday, what some people might term family in the low socioeconomic group. And I want to take my hat off to that gentleman. I won't name him in the House because he'd just be embarrassed. But he knows who he is. The issues that were traversed in the Select Committee, New Zealand First doesn't have a lot of problem with, and in fact we understand them. The 6 key points the 6 key changes that have been made to existing law lie around child-resistant covers, which were deemed to be adequate, means of restricting access to spa pools and hot tubs, and I acknowledge the Labor Speaker before, who pointed out that spa pools and hot pools were caught up in the legislation, and as time has moved on, the design of the spa pools has been such by the manufacturers that they have provided a perfectly secure means of providing that protection and safety for children, and to stop them drowning in these pools, and which makes the legislation somewhat redundant as far as they are concerned. We particularly like the fact that retailers and manufacturers are now going to be required to inform buyers about their obligations under the Act when they buy these spa pools, these hot tubs, these portable pools. We like the fact that they will be required to instruct the purchaser as to how to maintain and keep secure the pool that they have purchased and that they undertake to put on their property, and therefore, in doing so, undertake it to accept the responsibilities that come with that. That is, the responsibility of keeping that pool safe, and particularly keeping children safe from any accident that might occur. So those seem to us to be perfectly sensible. The other things that are perfectly sensible is getting some rationality and some consistency, standardisation in terms of how the territorial authorities exercise their duties and responsibility with respect to inspecting and certifying residential pools. This has clearly been an area where territorial authorities all over New Zealand have either struggled or simply not complied or been somewhat inconsistent cross-border. It's interesting, Mr Speaker, and yourself, being from a rural New Zealand, provincial New Zealand, know full well that there are some ratepayers out there actually have their property in two territorial authorities. It's just a matter of luck as to where the swimming pool is placed, as to whether or not you're subjected to inspection from, for example, Tararua District Council or Masterton District Council or Vicky Verka down in Carterton and South Wairarapa. So it is, and if you are a ratepayer who owns two properties, one which might be in South Wairarapa, one which might be in Carterton, and you have different, and you may well have two portable pools in both locations, to find that you're subjected to different inspection criteria and different compliances from two different councils can be somewhat frustrating if you are such an owner. So I don't know there'll be that many cases such as that, but there will be some. And it's nice to see that we're going to have some consistency applied across the board between territorial authorities due to the passage of this Act. What else? Graduated enforcement regime introduced with infringement notices as the preferred tool for compliance and court prosecutions only as serious breaches. Changing the way, I'm just got to remind myself, allowing for barriers other than fences to be used for restricting access to residential pools. Interesting conversation, this one, during Select Committee, Mr Speaker, when there was some debate as to whether a natural cliff provided adequate protection. Well, I guess if you're a child who has been trained and schooled at the by the SAS, and you know how to shimmy up a sheer face of a cliff, and then having exercised that, those talents and skills are then not able to swim in the pool that you might have fallen into when you got to the top of the cliff. We just don't quite see some of those things as being rational arguments. So if there is a sheer cliff, it will now be considered to be a suitable barrier. Mr Speaker, New Zealand First will support this bill through. We will watch for the amendments from the Labor Party, and we'll judge it on the merit of the debate as we go, but we will be supporting the bill.
I call Paul Foster-Bell.
Mana whakawā tuarua tēnā koe. Mr Speaker, this is a very sensible and practical